Bye, have a seat, please. Have a seat. Well, everybody sit down. Yeah.
that's long enough to reach that.
No, I don't think that's the only way. That's bad. You look at the camera.
That's all they got.
You only need about a foot.
Yeah, we could put it up here. Put them on right here.
Well, that's fine.
Well, that, the plug goes up to the other part of the unit.
Yeah.
See, the plug is up to the other part of the unit.
That's interesting.
Heavy enough to carry? Oh, it's not.
Plug there. Okay, good. Okay.
Everybody rise, please. Hear ye, hear ye, hear ye. This Honorable Circuit Court of the 11th Judicial Circuit of Florida in Fredette County is now open. All persons having business before this court, draw nigh, give attention, and ye shall be heard. God save the state of Florida and this honorable state. God save the state of Florida and this honorable state, the Honorable Judge Howard presiding. Please be seated. Court will come to order.
Mr. Harvey, I think you have filed some interim motions for the court first to consider.
Yes, sir. Initially, Your Honor, I'd like to introduce Robert Haggard. We have invited him to participate in the case. For this case, only as a special assistant to our office.
Welcome, Mr. Haggard.
Thank you, Your Honor. It's my pleasure.
He's an old timer to this circuit, so we don't have a problem with it. He made a good choice.
Thank you. Also, Judge, I'd like to present Mr. Neil Spielman, who's going to participate and help us as a consultant in jury selection. I'd like to present the court his qualifications for these.
Kiever?
Just on the Haggard thing, Judge, I'm sure the court is familiar with him because he's local, but we don't really know Mr. Haggard. Is he a member of the Florida Bar, just for the record?
Yes, sir.
Okay. And on this fellow, Judge, I don't believe we'd argued that motion yet. I hope we're just not going to make a decision until we argue. The expert for jury selection?
Is there any opinion on that? You just going to have his presence, or what is the situation?
Your Honor, we've made arrangements and he's agreed to be here and consulting with us. We do have a motion pending before the court for appointment of him as an expert.
Well, let me indicate to you, Mr. Spillman, you may be seated, both of you.
Thank you.
You may be seated, too. I think maybe we can take that motion up now, Mr. Harvey. First of all, prior to it, Madam Clerk, I have some exhibits that wandered into my collection from Tallahassee, and these are on the motion for change of venue, which we've heard, but should be filed in the file. It's Defendants 18, 19, 20, and 21. I'll file them with you at this time. These are copies, I think. I don't know whether they were marked, so they should be in the file. All right, your first motion then is you've got an appointment with a jury expert. All right, let me hear you on your motion.
Judge, just simply, we do need to have an expert consultant in jury selection, and Mr. Spielman is very well qualified. He's offered to come down. He has help us out at a very reduced rate as to what his usual fees are. And we appreciate the court's appointment of him as our expert.
That is for your consultation only?
Yes, sir.
Mr. McKeever?
Judge, we just reached the point where it's such a luxury to be a public defender on this case. It's unbelievable.
Judge, I object to that. That's not proper argument.
You know, someday you might be further on, Mr. McKeever. Maybe you'll fall in that.
I might be, Judge, but honestly now, jury selection is something a public defender with Mr. Harvey's qualifications and Mr. Haggard's certainly an expert in it. That's supposed to be something they do for a living, is picking juries. And I'm sure every public defender in the state would like to have the benefit of an expert such as this man sitting here. But we don't appoint him in every cotton-picking case, and I don't think we should in this one, Judge.
Well, I am not going to raise the gentleman to any appointment status, but if you want to confer with him during the course of the proceedings, you may feel free to do so. Now, I don't mean by that he can question any juror, but if you need to consult with him, you may feel free to do so.
Thank you, Judge.
During the course of the binary selection, he may stay forward of the bar. After the completion of that, he will present himself in the same way. Now, that's not to say I'm proving any payment. I'll talk about that with you later.
Will we be able to raise that issue later?
Yes, sir.
Thank you.
I'll let you raise the issue later.
Your Honor, may I raise an issue that is commensurate and collateral to this issue, and it is the position of counsel table. Generally, it is my feeling that the accused should always have the fullest right to communicate, and we do communicate aside from speech, we communicate by gestures and expressions. And part of and necessary to the effective assistance of Dr. Spielman would be a position in the courtroom where we would be in a posture to receive the most effective communication with the jury. And that is why I would ask the court if we could have the counsel table closest to the jury.
Well, if we have to depend on facial gestures and that type of stuff of convincing juries, the public defender system is a problem, because this court is going to come from our witness stand. I can appreciate it. I want to give you free access to everything there is in the courtroom. There's no priority of where people are sitting as far as the court is concerned. But I would let the record reflect that you will be in direct line of the jury's vision. There's no obstructions and there's nothing out of that matter. I would deny that motion, and we'll remain where we're seated, consistent with what we've always done. And now, Madam Clerk, here is another motion that was in pro se filed before me in Leon County. I'd like you to file in lawsuit. I think I have the original of the motion for the appointment of expert, which I'll file with you, that was transmitted to me by Ms. Good. Now, have you filed the original, or is this the original?
Judge, we sent you a copy, or we should have filed it.
Those things are filed. Now, if you don't have them, Madam Clerk, I have a copy of that. If you want to retain that copy, that's fine. What other motions do we have in preparation?
Your Honor, initially, Mr. Bundy has the first same motion, which he wants to present.
All right.
I don't know that we have a copy of it, Judge.
You don't have a copy of it, Mr. McKeever. I don't have copying facilities in my jail cell in the Dade County Jail.
Judge, I'm not speaking to Mr. Bundy, and I'd appreciate it if we follow the rules of evidence when we're handling
Well,
this case.
we are going to not consider a motion that you haven't provided a copy of. Let him see your motion, and then you may present it.
Thank you, Your Honor. I was going to bring that issue up to the court because that is one of the questions I think we have to determine.
Now, you may speak on the motion as they read it, and I will see the written motions, and you may proceed.
Thank you, Your Honor. As the court knows, I was being held in the Leon County Jail in Tallahassee, Florida, during the time the venue was in Leon County, and was transferred only yesterday to Dade County Jail in preparation for the proceedings this morning. In preparation for my transfer, I was informed by a Leon County Sheriff as to what items of my personal property I could bring and what items I could not bring. And I was informed by the Sheriff, and it was in fact the case, that I was only allowed to bring files directly related to the Chi Omega case and COVID. I was not allowed to bring with me any legal files or any legal materials or any legal source books. I might inform the court, for instance, in that category of things I was not allowed to bring was the Florida Rules of Criminal Procedure, the basic text. I was not allowed to bring typewriter. I was not allowed to bring stationery. I was not allowed to bring pencils, pens, envelopes, stamps, or anything with which I could prepare, otherwise participate in this defense. It's only through a last-minute gift from my attorney last evening that I was able to get a hold of a pen to write the motion that we have before the court today. I was not allowed to bring with me my files in the Lake City case, which, in the absence of those files, would preclude me from conferring with Mr. Africano, who was recently appointed to represent me in that matter. I was not allowed to bring with me legal files concerning collateral acts which the state intends to introduce in this proceeding, such as those acts involving credit card transactions, or those legal files dealing with the theft of a white van, which may or may not be a collateral act in this proceeding. Upon arriving in Miami and being booked in the Dade County Jail, I was taken to the 4th floor and spoken to by Sergeant Kratz of the Dade County Jail. And after Sergeant Kratz informed me of the rules and regulations of the jail, I was placed in a isolation cell, also known as a script cell, also known as a punishment cell. The cell is approximately 9 feet by 7 feet. It's illuminated by a light source which is well outside the cell and must filter through the steel bars into my cell. It has a shower stall and a bunk and a stool and a table built into the side of the cell wall. For all practical purposes, Your Honor, the cell effectively frustrates my ability to participate in my own in the preparation of my own defense, since the light source is totally inadequate to read by. The only way one can read in that cell is to hold a document outside the bars and read the document with the available light that filters from the light source outside the cell. The table and stool are totally inadequate because they're designed for right-handed people, and I unfortunately have the handicap of being left-handed. There's no way you can write on that stool and table being left-handed. There's a further question as to what I'll be allowed to have in my cell and as to whether or not I'll have exercise. Your Honor, considered individually, perhaps my complaints may seem insignificant, but I would ask the court to consider in their totality their impact on my ability to cooperate with counsel and participate with counsel. I might also say that because the Leon County Sheriff's Department waited until literally the last moment to bring me down here, I have not had an opportunity to fully discuss with counsel the proceedings which will take place today. And I will also state for the record and inform the court that since the change of venue ordered by this court in Tallahassee, and I don't know, I guess I was 10 days ago or 2 weeks ago, I have been able to consult with my counsel a total of approximately 3 hours in Tallahassee, and they came by last night as a talk. I feel that with the amount of time that my counsel have had access to me in these past 2 weeks, we have not been able to work together. They have not been able to inform me as to the course of the defense, both prior to the selection of the jury and during the selection of the jury, and for that matter, during the trial itself. And I would inform the court that one of my complaints that I voiced to Your Honor in Tallahassee was that I did not know, and I still do not know, maybe the names of the witnesses we're going to be calling, what we're supposed to get out of those witnesses, what part I'll play, if any, in examination of those witnesses, and so on. And I don't think this is because my counsel don't want to tell me. They've been pretty darn busy. They've been so busy chasing their tails almost that they haven't had time to talk to me. And I think that the very nature of that limitation is also a limitation on and my effectiveness as a defendant. What in the world can I add to a defense I don't know anything about? This is what, Your Honor, the Feretta Court, United States Supreme Court, was addressing itself to when they said that a defendant, the right granted by the Sixth Amendment is a right granted personally to a defendant, that the state cannot force upon a defendant a defense which he does not want. And I would say that by implication, the state cannot force upon a defendant a defense he has no knowledge of and no participation in the creation. And
I understand the scope of your motion.
Okay. Let me simply say that the relief I request in that motion is the return of legal documents, the improvement of lighting, exercise, and a number of other things I'd like the court to consider and rule on at the earliest possible opportunity. And there's also a motion, if I'm not mistaken, before the court by Ms. Good, a motion to continue based upon, in part, our inability to confer
right.
with one another.
Mr. McKeever?
Well, it sounds to me mostly like just in-house things, Judge, that can be worked out with the jail personnel and really Mr. Harvey or whoever wants to bring it to the court's attention. I feel like we've already argued this thing in Tallahassee about how much assistance he's got a right to and what kind of counsel and all that stuff, so I'm not going to belabor the court with the same arguments I've already made. I just think we can work this stuff out in-house.
All right, on this defendant's motion, the court's going to take it under advisement. The noon recess, I'll personally visit where you're incarcerated, and I'll make a decision based upon that. We'll see what's there.
Thank you.
You may file this, Madam Clerk. Do you want to take the motion to continue now, Ms. Good?
Yes, Your Honor. We filed a motion to continue on the grounds, as Mr. Bundy has stated, that we have had an inadequate opportunity to confer with the defendant. We did meet with him on Saturday, June 16th, after we changed the venue on the 12th. On the 20th, the defendant was transported to Columbia County. I attempted to make arrangements to visit with Mr. Bundy that evening when he returned at about 6:30, and Mr. Art Golden told me that it would not be possible for me to visit with Mr. Bundy that evening. I attempted to visit with him on the morning of the 21st, so that was just a very brief conference. And as you notice, I have had to scratch out part of the motion on the original there, because although we had intended to confer with Mr. Bundy again this morning, we were not able to. We were informed by the jail that problems of transportation and his recent arrival, that they just hadn't worked out the logistics of that yet, and therefore we really feel unprepared to proceed today with jury selection, and would request an adequate period of time to confer with the defendant.
What do you want to confer with him about on jury selection, Ms. Good?
Your Honor, the defendant is representing himself here as co-counsel, and we do have an expert in jury selection that we're conferring with. And there are matters that we do need to talk to him about and determine concerning the jury selection procedure.
All right. Anything from the state?
Again, Judge, I've already argued this motion. They've had 6 months since they were appointed in January. They started picking a jury in Tallahassee, and I presumed at that time that they had conferred with him and had a feeling for what they wanted in a jury. And now here we are again 2 weeks later in Miami with the same general situation of picking a jury.
Your Honor, in Tallahassee, we also had a pending motion to continue that was denied, and we were totally unprepared for that voir dire. And very luckily, venue was changed.
Wasn't lucky.
So,
It was legally.
well, luckily and legally. Luckily for us, we've had perhaps 10 more days to try and prepare, but as you know, the arrangements to transfer to Miami have been involved also, so we haven't been able to devote all of our time to merely preparation for trial, where we were unprepared before, and these matters do
How much
remain.
time you think you need?
Your Honor, I think we need at least a day.
All right. Let the record reflect the motion came on to be heard. The motion in its totality will be denied, but I'll extend the noon lunch hour for a period of time for us to visit the jail and for them to discuss further the jury selection process with Mr. Bundy. We'll be in noon recess on the matter until from 12 till 2:30. That'll give you 2.5 hours. And we'll make arrangements to have him available for you to talk with him at that time. Preliminary discussion with juries during the morning concerning minimum qualifications are standard and not intrinsic or unique to this particular case, and I think the court, in orderly dispensing business, can proceed with them without any harm to the defendant. You've made the court's going to allow you the presence of the jury selection expert, Mr. Spillman, so I assume that his comments will be more significant to you in the early stages than those of Mr. Bundy. So we'll proceed with that. Now, what other motions you have?
Well, the next motion we'd like to take up is the motion to prohibit further prejudicial extrajudicial statements by Sheriff Caceres, which we filed this morning. We have a videotape prepared.
Is the sheriff here?
Yes, sir. Your Honor, we've
Well, there's no need in reliving what's already gone into. I think the court can simply say to this that
Judge, the last thing that we're relying on is something that happened last week the court may not be aware of. We've got a videotape of the president, that's all the evidence we want to present on it.
Is it ready to proceed?
Yes, sir.
Sheriff, you want to come up and make sure that... Come over on. Take one of those chairs over there and move that where he can see it for sure. Can you see this, Judge? You can move it out a little bit if you want to. That's fine. Tilt it just a little bit so Sheriff Caceres can see it also. Turn your cart just a little bit. Won't it be easier, gentlemen? Can you see it there, Sheriff? Back it up a little bit, gentlemen. I think maybe we can all see it. That's good. Thank you. Yeah, this is all right. Without the presence of the jury, I don't have any objection.
Well, we talked about personality traits, confinement in the cell, the property that he has with him, what property that's in his cell now that may not be possible to have in the cell here, just those kinds of things.
Dade County Corrections Director Jack Sandstrom, who is in charge of security, says he's prepared for Bundy's arrival.
Oh, there's always the possibility of escape. Personally, I feel more concerned for his safety from some bizarre kind of situation than I do for as far as escape is concerned.
Law officials examined the single high-security cell in which Bundy will be placed for the duration of the trial. They also took a look at the courtroom where preparations are already being made for the 3 to 4 week long trial. A special room has also been set up where Bundy, who is partially acting as his own attorney, can consult with his defense counsel on the progress of the case. The trial is set to begin this coming Monday. Robin Lloyd, Channel 4 News.
Did we get the interview? I think I might have missed the beginning part. Can I run it back?
Security says he's prepared. What took place in the chambers of Chief Administrative Judge says he will come down to Miami sometime early next week to talk to Judge Cowart, jail officials, and police about security in this case. He says he has no intentions of giving the exact date when Bundy will be transported. Robin Lloyd, Channel 4 News.
We'll advise his office when we're moving across there, but also we'll have enough escorts to take him into the court.
It was the first time Dade and Leon County law officials had met to talk over what security measures should be taken to transfer accused murderer Ted Bundy to Miami. The meeting took place in the chambers of Chief Administrative Judge Edward Cowart, who ordered the change of venue a week ago because of the tremendous publicity surrounding the case in Tallahassee. Since the trial was postponed on June 12th, Bundy has been kept in a high-security cell in Leon County Jail. Local officials say he has made no attempt to escape. Bundy became known as an escape artist in Colorado after twice escaping from jail. Leon County Sheriff Ken Caceres says his chief concern was to inform local authorities about Bundy's charm and intelligence, and how he uses those traits to try to place jail officials off guard.
Well, we talked about personality traits.
I'll continue from where you were before.
Everybody please return to your seats.
turning this over to the court.
David Marcus.
All right, Mr. Harvey, what's your motion?
Your Honor, on that motion, submitted to take, and I've submitted a transcript of it, and I've outlined in the motion what I consider to be a continuing course of conduct by Sheriff Fitzgerald, and what looks to be a deliberate attempt to try and poison the minds of no matter where we're going to have this trial. And I would ask the court, without further argument, to please instruct the sheriff to withhold any further prejudicial statements about our client until this case is over.
Do you have any response?
Well, Judge, of course, we respond with extreme objection to his statements about the sheriff's motives and intentions and purposes and whatnot. The man answers questions that are asked of him honestly in the press, and just because it's disseminated is something that has been a problem for all of us, and that's why we're down here in Miami, I think, because there has been so much press coverage. But we object to the way in which he's phrased his motion. We don't object to the court, of course, instructing as many people as possible to try to just put this case on in a low-key fashion, and let's get it to trial and get it done with.
Mr. Keever, that specifically is the court's instruction. I do think that there are a lot of trying factors involved in the trial of the case that sometimes aren't in all cases. I think the best thing that all of us that can do that are intimately involved in this thing is just that. And we would ask all parties, include counsel, the defendant, the state, everybody involved in it to maintain that particular position. And remember that a jury of peers are what we're trying to collect and select. And I don't find any necessity of entering a restraint order or a gag order. I just simply commend to them as constitutional officers and to all of you as constitutional officers to refrain from further comment or unnecessary comment about the case. An attempt to do just what I've said from the beginning, to let us proceed with the legal issues in the case and get them resolved. That's what we're here for, and I don't think we need to issue any further order, but I will issue that order, Mr. Harvey, that we all refrain from any further communications other than is necessary, and they be made in the courtroom. Now, that's one uniqueness of the proceedings that are taking place. Everything that transcribes here in the courtroom, of course, is front and center, and I don't think there is any need for us to further disseminate those things that we don't talk about in court. I think basically that's our idea, and I don't, by saying that, I don't communicate that some of the language that you said in your motion is a finding by the court that there has been anything willful, malicious, or that there's been anything that violates what he was supposed to do. I simply say that I think the time has arrived where we're going to try to move this trial through the positions of a trial as fairly and impartially and without any disseminated prejudice on the part of anybody, so that we can give this young man the fair trial that we've labored pretty hard for and what we're all here for. I think with that we'll dispose of the motion. Now, what other motions you have?
Judge, we've got a motion for additional peremptory challenges, which I understand the court granted us 25 Tallahassee.
In the Tallahassee situation, it doesn't carry over to.
Well, that's what I anticipated. So we have filed a motion for additional peremptory challenges here also. And in support of that, we've subpoenaed a number of newspaper articles from the local media to be entered as exhibits. I'm not sure if the clerk has got all of those exhibits at this point, or whether there are people here with the exhibits.
Well, let me explain to you that I am not going to deny you some consideration in getting a jury. That's one of the things that we talked about at the beginning. The excessive number that I granted in Tallahassee was based upon the particular setting in Tallahassee. And when we begin to question some of these jurors, I will indicate early in the proceeding whether or not, and I think that's going to be the guiding factor in my mind, that I'll indicate to both counsel early in the proceeding if there is necessary in the concept of proceeding with fairness and impartiality that we grant additional time. I'd like to take this motion under advisement and rule on it when we see the census. I will say to you that if necessity mandates we give you additional charges, we're going to give them to you. I'm not going to be quite as liberal as I was until I had. I don't think the reason is that. And I will tell you well in advance when we begin to preliminarily question some of these jurors so that we can get a feel of what's there, similar to what we did in the motion for change of opinion. I think I can get it early in the proceeding and will allow you some additional if necessity demands. I have a feeling you'll get them without using all the perimeter challenges that you have now, unless you just want to use them. All right. Let us see what necessity dictates, and I'll assure you that we'll do, if necessary, we'll give you some more. Think that we can get a better sense on that, as I said, as we proceed along.
Judge, attached to that motion, if the judge is going to take it under advisement, I'd like the court to be aware that we have attached, Dr. Hesselbar has done a preliminary public opinion poll in Dade County, and I've attached the results to the motion. I'd like the court to consider it.
You know, she's pretty random.
I can't explain the statistics.